Seated, everyone, and thanks everyone for being here. Is everybody ready to proceed?
Yes, please, sir.
All right, then show the jury in. We agreed on 45 minutes. Anybody want any 2-minute warnings? Half and half, 2-minute warning. Okay, I'll give you that. You got it. Good morning. You know, nothing personal. Y'all seem like really good people, but I hope today's the last time I tell y'all good morning. Yesterday, I trust no one had any problem with the court's instructions not to discuss the case, not allow anyone to discuss the case with you, not form or express an opinion, investigate the case in any manner. If you had any problems determined in the trial of the case in that regard, speak now, forever hold your peace. I trust you have it. Yesterday, when we were breaking yesterday afternoon, I let you go early because I knew we had to get jury instructions together. I debated on whether just keep y'all a while and see if we could get those done quickly and let y'all start the deliberations yesterday evening. But about 9:30 last night, when we were finally leaving the courthouse, I think I made the right decision to let y'all go home. But we have worked hard getting these together. We apologize for the delay to you, but as I said before, this is important. We want to get it right, and I appreciate y'all's patience with us. This morning, I am going to read you the jury instructions. You will then have closing arguments by the attorneys. State subject matters burden of proof will go first. The defense will then have its closing argument, and then the state will have its on the record. Other than the objections previously stated yesterday when we were having our jury conferences, are there any objections to the instructions given? Any additional objections? All right. Here we go. Pay attention. I will say this. It's going to take a little while to read, bear with me, but you will also be given written copies of these jury instructions, but still pay attention. All right. Members of the jury, you have heard the testimony and received the evidence introduced in the course of this trial. The court will presently instruct you as to the rules of law which you will use and apply to the evidence in reaching your verdict. When you took your place in the jury boxes, you made an oath that you would follow and apply these rules of law to the evidence in reaching your verdict in this case. It is therefore your duty as jurors to follow the law which I shall now state to you. On the other hand, it is your exclusive province to determine the facts in this case and to consider and weigh the evidence for that purpose. The authority thus vested in you is not an arbitrary power, but must be exercised with sincere judgment, sound discretion, and in accordance with the rules of law stated to you by the court. Both the state of Mississippi and the defendant have a right to expect that you will conscientiously consider and weigh the evidence and apply the law of the case, that you will reach a just verdict regardless of what consequences of such verdict may be. It is your duty to determine the facts and determine them from the evidence produced in open court. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. You are the sole judges of the facts in this case. Your exclusive province is to determine what weight and what credibility will be assigned to testimony and supporting evidence of each witness. You are required and expected to use your good common sense and sound honest judgment in considering and weighing the testimony of each witness who has testified. Although you, as jurors, are the sole judges of facts, you are duty-bound to apply the law as stated in these instructions to the facts as you find them from the evidence before you. You are not to single out one instruction alone as stating the law, but you must consider these instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law, regardless of an opinion you may have as to what the law ought to be. It would be a violation of your sworn duty to base your verdict upon any other view of the law than that given. Arguments, statements, and remarks of counsel are intended to help you understand the evidence and apply the law, but are not evidence. Any arguments, statements, and remark having no basis in the evidence should be disregarded by you. The evidence which you are to consider consists of the testimony of the witnesses and the exhibits offered and received. Production of this evidence, courts, is governed by rules of law. From time to time during the trial, it has been my duty as judge to rule on the admissibility of evidence. You must not concern yourself with the reasons for the court's rulings, since they are controlled and governed by rules of law. You should not infer from any rulings by the court on these motions or objections to the evidence that the court has any opinion on the merits favoring one side or another. You should not speculate as to possible answers and to questions which the court did not require to be answered. Further, you should not draw any inferences from the content of those questions. You would disregard all evidence that was excluded by the court from consideration in the course of the trial. You are not bound by any rules of parliamentary procedure in your organization or in your deliberation, but the court suggests that you choose a person to speak for you. You may vote on your individual's belief either by show of hands, secret ballot, or any other method you choose. If in stating the law to you, I repeat any rule, direction, or idea, or if I state the same rule in a different way, no emphasis is intended, and you must not draw any inferences therefrom. The form of the verdict is suggested in another written instruction or instruction. Your verdict may be in one of the suggested forms, and it should be written in the handwriting or printing of one of the individual jurors on a separate sheet of paper furnished to you for that purpose. None of the individual jurors has to sign your verdict. The order in which these instructions are given to you and the manner in which the instructions and exhibits are numbered has absolutely no significance. You will have with you in the jury room all the papers and evidence applicable to this case. Although during the trial other papers, documents, exhibits, or charts may have been mentioned to you, once you have entered the jury room for deliberation, no other documents, papers, exhibits, or charts may be given to you. Transcripts of the trial testimonies or parts of the trial testimony are not available. When you enter the jury room for deliberation, the court suggests to you that you discuss the facts of the case and review these written instructions before you begin voting or attempting to decide the case. The burden of proving the defendant guilty of every material element of the crime with which the defendant is charged is upon the state of Mississippi. The law makes no distinction between direct and circumstantial evidence. It requires that before you return a verdict of guilty, the state of Mississippi must prove beyond a reasonable doubt that the defendant is guilty from all the evidence in the case. The law presumes every person charged with the commission of a crime to be innocent. This presumption places upon the state of Mississippi the burden of proving the defendant guilty beyond a reasonable doubt. The presumption of innocence attends the defendant throughout the trial and prevails at its close unless overcome by evidence which satisfies the jury of his guilt beyond a reasonable doubt. The defendant is not required to prove his innocence or to offer any evidence at all. The verdict of the jury must represent the considered judgment of each juror. In order to return a verdict, it will be necessary that each juror agree thereto. In other words, all 12 of you must agree on a verdict in this case. It is your duty as jurors to consult with one another and to deliberate in view of reaching an agreement, if you can do so without violence to your individual judgment. If each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if convinced that your previous opinion was erroneous. But do not surrender your honest convictions as to the weight of evidence or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of reaching a verdict. Upon retiring to the jury room, you will select one from among your number to act as a foreperson. The foreperson will preside over your deliberations and will be your spokesperson before the court. If it becomes necessary during your deliberations to communicate with the court, you may send a note by the bailiff. During deliberations, no member of the jury should ever attempt to communicate with the court by any means other than a writing, and the court will never communicate with any member of the jury on any subject touching the merits of the case, otherwise in writing or orally here in open court. Bear in mind also that you are never to reveal to any person, not even me, how the jury stands, numerically or otherwise, until you have reached a verdict, unless asked by me in open court. The defendant has a constitutional right not to testify on his own behalf in this case. You are not to make any conclusions or inferences of guilt about the defendant as a result of the defendant exercising his right not to testify on his own behalf. You will not consider in any way during your deliberations the defendant's decision not to testify. Each person testifying under oath is a witness. You have the duty to determine the believability of the witness. In performing this duty, you must consider each witness's intelligence, the witness's ability to observe and accurately remember, the witness's sincerity, and the witness's demeanor while testifying. You must consider also the extent to which the witness is either supported or contradicted by other evidence, the relationship the witness may have with either side, and how the witness might be affected by the verdict. You must consider any evidence of the witness character. You must consider any evidence of the witness's character for truthfulness. In weighing a discrepancy by a witness or between witnesses, you should consider whether it resulted from an innocent mistake or a deliberate falsehood, and whether it pertains to a matter of importance or an unimportant detail. You may reject or accept all or any part of a witness's testimony, and you may reject part and accept other parts of a witness's testimony. After making your own judgment, you will give the testimony of each witness the credibility, if any, as you may think it deserves. The weight of the evidence is not necessarily determined by the number of witnesses testifying as to the existence or non-existence of any fact. You may find that the testimony of a smaller number of witnesses as to any fact is more credible than the testimony of a larger number of witnesses to the contrary. Any fact in this case may be proved by either direct or circumstantial or evidence or both. Direct evidence is direct proof of the fact, such as testimony by a witness about what the witness personally saw, heard, or did. Direct evidence is a testimony of someone who claims to have actual knowledge of a fact. Direct evidence is simply evidence which, if you believe, it directly proves a fact. An example is a witness testified that he saw it raining outside and you believed him. That would be direct evidence that it is raining. Circumstantial evidence is proof of fact or facts from which you could conclude by your reason and common sense that another fact exists, even though it has not been proven directly. Circumstantial evidence is proof of one or more facts from which you could find another fact. Circumstantial evidence is simply a chain of circumstances that indirectly proves a fact. An example is if someone walked into the courtroom wearing a raincoat covered with drops of water and carrying a wet umbrella, that would be circumstantial evidence which you could conclude that it was raining. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. You as a jury should decide how much weight to give to any evidence. Deliberate design means an intent to kill without authority of law and not being legally justifiable or legally excusable. Deliberate always indicates full awareness of what one is doing and generally implies careful and unheard consideration of the consequences. Design means to calculate, plan, or contemplate. Deliberate design to kill a person may be formed very quickly and perhaps only a moment before the act of killing the person. However, deliberate design cannot be formed at the very moment of the fatal act. The court instructs the jury that a killing occurring while engaged in the commission of a kidnapping includes the action of the defendant leading up to the kidnapping, the action of the kidnapping, and the aftermath of the kidnapping. The court instructs the jury that inveigle means to lure or entice through deceit or insincerity. Inveigling has no component of force, but only coaxing. Acting with a depraved heart is when a person acts in a highly dangerous way, which shows that the person does not care for the safety of human life. Even if someone does not intend to kill any particular person, he can still be guilty of murder if he acts with a depraved heart and a person is killed as a result. Culpable negligence is negligence of a degree so gross as to be tantamount to a wanton disregard of or utter indifference to the safety of human life. Negligence is doing something that a reasonable, careful person would not do under similar circumstances, or failing to do something that a reasonable, careful person would do under similar circumstances. Second-degree murder and culpable negligence manslaughter are distinguishable simply by the degree of mental state of culpability. In short, second-degree murder involves a higher risk of recklessness from which malice may be implied. The defendant, Sheldon Timothy Herrington Jr., is charged with the offense of capital murder. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, did unlawfully and feloniously without authority of law and with or without any design to effect death, killed Jimmie Dale J. Lee III, a human being, while Sheldon Timothy Herrington Jr. was engaged in the commission of the crime of kidnapping with or without intent to secretly confine, inveigling Jimmie Dale J. Lee III with the intent to cause Jimmie Dale J. Lee III to be confined against his will, then you should find that Sheldon Timothy Herrington Jr. guilty of capital murder. If you fail to find the defendant, Sheldon Timothy Herrington Jr. guilty of capital murder, then you shall continue your deliberation to consider the crime of first-degree murder. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, did willfully, unlawfully, and with deliberate design to effect the death of Jimmie Dale J. Lee III, killed Jimmie Dale J. Lee III, a human being, then you shall find Sheldon Timothy Herrington Jr. guilty of first-degree murder. If you fail to find the defendant Sheldon Timothy Herrington Jr. guilty of first-degree murder, then you shall continue your deliberation to consider the crime of second-degree murder. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, did willfully, unlawfully, and feloniously kill Jimmie Dale J. Lee III, a human being, without premeditated design to effect the death of Jimmie Dale J. Lee III, while engaged in the commission of an act eminently dangerous to others and evincing a depraved heart, regardless of human life, then you shall find Sheldon Timothy Herrington Jr. guilty of second-degree murder. If you fail to find the defendant Sheldon Timothy Herrington Jr. guilty of second-degree murder, then you shall continue your deliberations to consider the crime of manslaughter, culpable negligence. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, unlawfully and feloniously killed Jimmie Dale J. Lee III, a human being, with culpable negligence by engaged in dangerous sexual activity with Jimmie Dale J. Lee III, then you shall find Sheldon Timothy Herrington guilty of manslaughter, culpable negligence. If the state has failed to prove any of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty of capital murder, first-degree murder, second-degree murder, and manslaughter, culpable negligence. The court instructs you that all 12 of you must reach and agree upon a verdict. If the court instructs the jury that if all 12 of you reach and agree upon a verdict, you shall return the verdict to the court in one of the following forms. If you find Sheldon Timothy Herrington Jr. guilty of capital murder, the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington Jr., Sheldon Timothy Herrington guilty of capital murder. If you do not find the defendant guilty of capital murder, then you shall continue your deliberations, consider the lesser charge of first-degree murder. If you find Sheldon Timothy Herrington Jr. guilty of first-degree murder, the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington Jr. guilty of first-degree murder. If you do not find Sheldon Timothy Herrington Jr. guilty of first-degree murder, then you shall continue in your deliberation and consider the lesser charge of second-degree murder. If you find Sheldon Timothy Herrington Jr. guilty of second-degree murder, the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington Jr. guilty of second-degree murder. If you do not find Sheldon Timothy Herrington Jr. guilty of second-degree murder, then you shall continue in your deliberations and consider the lesser charge of manslaughter culpable negligence. If you find Sheldon Timothy Herrington Jr. guilty of manslaughter culpable negligence, the form of your verdict shall be. We, the jury, find the defendant Sheldon Timothy Herrington Jr. guilty of manslaughter culpable negligence. If you do not find Sheldon Timothy Herrington Jr. guilty of manslaughter culpable negligence, then the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington Jr. not guilty. Your verdict must be in one of the forms written above. You should write your verdict on a separate sheet of paper. It does not need to be signed. Did the court read the instructions that were
Yeah, we approached just a second.
okay?